Hi, everybody. Welcome in. Thank you so much for coming to watch the Bales 2025 finals. I'm Ben, and along with Annalise, we are the student directors. I want to give a big thank you to everyone who helped make this happen. Thank you to our judges who are here today. Thank you, everyone, for showing up. It's so great to see so many former competitors and trial team coaches here. We're going to ask that during this, you all keep your phones off or on Do Not Disturb, all laptops down. We don't want to have any clicking disturb our competitors. And also, we're going to ask that nobody leave during the cases. We don't want the sounds of the door opening and closing to distract people. We're going to have a break about an hour in and then right again before the close. And without further ado, we're calling the case State of Eureka. State of California. It's always Eureka. State of California versus Jordan Brier.
All right, before we begin, I will take appearances and pronouns from both sides, starting with the prosecution, please.
Good afternoon, Your Honor. My name is Sienna Horvath for the people of the state of California. Pronouns are she, her.
Good afternoon, Your Honor. My name is Daniel Casement for the people of the state of California, and I use the pronouns he, him.
Thank you very much. Appearances from the defense.
Good afternoon, Your Honor. Cait, Meyer, using she, her pronouns for the defense.
Good afternoon, Geronimo, Owen for the defense. I use he, him pronouns.
Very good. You can all be seated. Are there any housekeeping matters before we begin with opening statements?
Yes, Your Honor, a few housekeeping matters. First, the prosecution and defense have both agreed to pre-admit 4 exhibits. That'll be Exhibit 7, a 911 call transcript. Exhibit 9, an email from the defendant to her assistant director regarding the hiring of the armorer. Exhibit 10, an article from the Eureka News Network called A Call to Arms, Firearms and Film Need Fixing. Exhibit 11, a product recall notice for the Hart & Weschler Model 54 revolver. Would Your Honor like us to tender copies to the bench?
I have copies. Thank you for asking. Defense has the prosecution correctly stated that you've stipulated to the admissibility of those 4 exhibits.
Yes, they have, Your Honor.
Okay. Exhibits 7, 9, 10, and 11 are admitted at this time.
We would also like to draw the court's attention to the deposition of an unavailable witness, Kyrie McLorg, a crew member from the set of Spur. Both prosecution and defense have agreed that at any point during either case in chief, portions of this deposition may be read onto the record, and all objections to reading this deposition onto the record have been waived by both sides.
Is that a correct statement of your agreement as well?
Yes, Your Honor.
Very good.
And finally, as of this morning, we received a final supplemental list of stipulations with 3 stipulations. Would Your Honor like us to tender this list to the bench?
Yes, if you don't mind. Thank you.
With that, the prosecution is ready to proceed.
Very good. Any housekeeping from the defense?
Yes, Your Honor. The defense would like to inquire about if you have any preferences as to where witnesses should direct their testimony to.
Witnesses and counsel should direct their testimony to the jurors in the jury box. Don't worry about me.
Understood. Thank you, Your Honor.
All right. If nothing else, then the prosecution can begin with opening statements.
Just one final housekeeping matter. We'd like to ask Your Honor's preferences regarding movement about the courtroom. Should we ask your permission before approaching witnesses and the bench, and shall we move freely about the well, or would you like us to ask your permission before we enter?
You can move freely about the well. I would ask that you ask permission before approaching a witness.
Yes, Your Honor.
All right. Anything else to take care of?
No, Your Honor, the prosecution is ready to proceed.
All right. Begin whenever you're ready.
Your Honor, members of the jury, may it please the court. It was only a matter of time. On October 21st, 2021, J.U. got up and went to work. You see, J.U. was a cinematographer working on the set for the film Spur, a new Western, the brainchild of one Hollywood legend, actor and producer extraordinaire, Jordan Brier. It was a dream come true, working on passion projects alongside colleagues and friends that Mr. J.U. expected to be the best. Unfortunately, this dream soon turned into a nightmare, because on October 21st, J.U. was shooting a scene with the defendant, Jordan Brier. A scene in which Miss Brier points a gun directly at the camera, directly at J.U. And on that day, October 21st, that gun contained a bullet. Not a dummy round, a real bullet. Not a blank or a gunpowder charge, a real bullet. A bullet that exited the gun in Miss Brier's hand, struck J.U., and killed him. And because of that incident, October 21st, we are here today to bring charges of involuntary manslaughter against Miss Brier. We, the people, have the burden of proof today beyond a reasonable doubt, and members of the jury, we will meet that burden today. We're going to show you that Miss Brier took 3 massive risks leading up to the shooting. Number 1, Jordan Brier hired an incompetent armorer. Number 2, Jordan Brier's set was chaotic and dangerous. And number 3, Jordan Brier pointed a loaded gun directly at J.U.'s head. Now let's take those one by one. First, Jordan Brier hired an incompetent armorer. You're going to hear today from Deputy Avery Laycook, the officer who responded to the shooting and the officer who led the subsequent investigation. They're going to tell you that when it came to doing their background research for the person they hired to oversee guns on their set, Ms. Brier didn't do her homework. You're going to hear that the person they hired, went by the name L.V., was a young, green Hollywood newcomer in the armory business. And yet, despite their youth, they had an impressive history of complaints for dangerous firearms on set. And you're going to hear that they had been fired from their second ever job after an accidental gun discharged on set, striking and injuring a crew member. You're going to hear that all of this information was readily available, a short and simple Google search away, and yet you're going to hear that the defendant never even saw it. After hiring an armorer with such a loaded history as LV, it was only a matter of time before dangerous conditions emerged on set, which of course is exactly what happened. That takes us to point 2. Conditions on the set were chaotic and dangerous. You're going to hear that prior to the shooting, multiple crew members filed multiple complaints alleging unsafe working conditions on set, and yet these conditions persisted. You're going to hear that crew members would take the guns out of the armory, fill them with live ammunition, which had no business being on set, and use these guns for target practice during their lunch breaks. You're going to hear that the very gun Miss Brier used on that day was the next in a line of guns previously recalled for unsafe safety mechanisms. And you're going to hear that in the weeks leading up to the shooting, on 2 other occasions, prop guns accidentally discharged on Jordan Brier's set. members of the jury with such an unsafe set, again, it was only a matter of time until somebody got hurt. Which, of course, takes us to number 3, and the day of the shooting of J.U. You're going to hear from the defendant herself today. She's going to come to the stand and tell you that she didn't know the gun was loaded. She hired an armorer. She did her job. It was out of her hands. Of course, we do know that it was very much in her hands that day. J.U.'s life was in her hand. The gun that shot him was in her hand. You're going to hear the defendant say that her set was safe. There were instructional videos used, and that she was present at these trainings. You're going to hear that she knew about the guidelines for the safe handling of firearms on set, that she was told to treat every gun like it was loaded. But she can't tell you who told her the gun was unloaded. She can't tell you who checked the gun before it was given directly to her. But Ms. Brier can tell you that she didn't turn on the safety. She can tell you that she didn't personally check the gun, despite being told that every new firearm needed to be personally inspected. It was only a matter of time, and for J.U., on October 21st, 2021, time ran out. Which is why, at the end of this case, my co-counsel, Sienna Horvath, is going to ask that you find the defendant guilty. Thank you.
Thank you, counsel. Opening statement from the defense.
May I proceed, Your Honor?
You may.
She was told the gun was cold, and Jordan Brier had no reason to suspect otherwise. On October 21st, 2021, Jordan was in a church on the Spur movie set when LV, the film armorer responsible for weaponry on set, handed her a prop gun and confirmed there were no bullets inside of it. Jordan took the gun and began rehearsing with it. She drew the gun and aimed it at the camera when suddenly the gun malfunctioned, spontaneously discharged in her hand, tragically injuring one crew member and killing her friend, J.U. She didn't even know there was live ammunition on set. She was told the gun was cold, and Jordan Brier had no reason to suspect otherwise. The prosecution wants you to believe that because of this accident, Jordan is responsible for involuntary manslaughter. In order to prove this, they must show that Jordan acted so differently from an ordinarily careful person that she created a high risk of death or great bodily injury. And they must show that Jordan behaved this way beyond any reasonable doubt. This is the highest burden of proof in our legal system. And the prosecution won't be able to meet this burden today, which we will establish by showing you 3 things. First, that as an actor and producer for Spur, Jordan did her job. And while she deeply regrets hiring LV, she could not reasonably anticipate his mistakes. Second, that Jordan did not pull the trigger. And third, that Jordan did not know there was live ammunition on set, let alone in the gun. And she could not have reasonably known there was live ammunition in the gun. She was told the gun was cold. So let's walk through exactly how this accident happened. as you'll hear today, Jordan first joined Spur in the pre-production stage. As a seasoned film professional, she knew that Spur needed an experienced, reputable armorer on set to ensure gun safety. It was only after a careful vetting process and learning about LV's extensive experience as an armorer that Jordan decided to hire LV. She truly believed LV was that experienced, reputable armorer. In an email to her assistant director, she wrote that with LV on board, she believed it would be a safe set. But little did Jordan know that this was not a safe set. While Jordan was juggling the many tasks of an actor and producer on set, LV was not doing his job. As you'll hear today, crew members were putting live ammunition in the prop guns and using them for target practice during their breaks. There were also 2 prior gun accidents on set before the October 21st incident. And nobody, not LV, not another crew member, reported any of this to Jordan. Meanwhile, Jordan diligently attended all safety trainings and even hired a medic to remain on set just in case. On the day of the accident, you'll hear that Jordan was careful, just like any other day on set. She waited for LV to confirm there were no bullets inside of the gun because Jordan is not a gun expert. She trusted the expert. She believed the expert. And as she drew the gun in her hand, she was not recklessly waving her arm everywhere. Her movements were controlled, cautious. And finally, you'll hear from Jordan today that she would have never pulled the trigger, even on a supposedly unloaded prop gun. Yet the gun malfunctioned, spontaneously discharged in her hands. Only a day after this traumatic accident, Jordan is questioned by the police. She wants to answer all of their questions. She even waives her Miranda rights. But this is only a day after losing her friend. She is mourning that friend and still deeply concerned about the other victims' well-being. During this questioning, she also learns about all of those safety issues on set for the very first time. She's shocked, horrified, confused. But Detective Laycock, the officer in charge of that investigation, stopped his investigation at interviewing Jordan. He didn't formally interview LV or Sage Cleveland, the assistant director. He didn't check the gun for fingerprints or have the lab even evaluate how the gun fired. He just took one look at the famous Hollywood star and decided she's the movie villain. Members of the jury, Jordan was not a perfect producer. We're not arguing that this was a perfectly run set. But the evidence in this case will show you that Jordan did not know about those safety issues on set or LV's many mistakes. And no reasonable person, no reasonable producer in her shoes would have known about all of those issues on set. And that's why, at the end of today's trial, my co-counsel Geronimo Owen will ask that you find Jordan Brier not guilty of involuntary manslaughter. Thank you.
Thank you, counsel. Are the people ready to call their first witness?
Yes, Your Honor. The people call Deputy Avery Laycook to the stand.
All right.
Good afternoon, Mr. Laycook.
Good afternoon.
Will you please introduce yourself to the jury?
My name is Avery Laycook.
And Mr. Laycook, what do you do for a living?
I'm a deputy with the Los Angeles County Sheriff's Office.
How many years have you been a police officer?
I've been in law enforcement since 2000, and I've been a detective specializing in homicide investigations since 2008.
Deputy, do you require any training to become a police officer?
Yes, I have a BA in criminology from San Jose State University and an MS in forensic science from the University of Hawaii. After that, I completed the police officer standards training or post-certification. It's a 6-month course in law enforcement techniques.
Have you received any other specialized training?
Yes, apart from my general training, I completed a course in crime scene analysis, specifically as it relates to homicide investigations. That includes ballistics, blood spatter analysis, evidence collection and preservation. Overall, I've been involved in about 450 investigations, including nearly a dozen homicide investigations.
Deputy, during your career, over 2 decades in law enforcement, have you received training in the use of firearms?
Yes, I have extensive experience studying and applying best practices for firearm safety. I hold a firearm safety certificate from the California Department of Justice. I'm also a state-certified firearm safety instructor, and I have extensive experience lecturing at law enforcement academies on best practices for firearm safety in both personal and professional settings.
Your Honor, the prosecution moves to admit Detective Avery Laycook as an expert in the fields of homicide investigation and firearm safety practices.
Any objections to Deputy Laycook being offered as an expert in those areas?
Yes, Your Honor, we object to Officer Laycook being offered as an expert in firearm safety. We believe that Officer Laycook is going to be asked to give testimony on the firearm safety on this set in particular, and his background is primarily in law enforcement and firearm safety training as it relates to law enforcement, which is, we believe, a totally different situation than a set where you're using prop guns, where you're using fake ammunition. He has no experience in those matters at all, and we believe that allowing him to testify on this would just confuse the issue.
How do you respond to that?
Your Honor, Deputy Laycook has already testified that he is paid to instruct at law enforcement academies and elsewhere in gun safety matters, in both a personal and in a professional setting. Additionally, guns are guns. And so while the location of where you are handling the gun might change, that does not mean that Deputy Laycook's recommendations and guidelines that he teaches are going to be incorrect or different than those that would be normally practiced or followed on a set.
Defense counsel, I think you've raised a valid concern, but I think it's premature without knowing how far they plan to go with the testimony. So I'll overrule it this time, but feel free to re-raise if you think it becomes an issue.
Will do. Thank you, Your Honor.
May I proceed?
You may.
Deputy, will you please tell the court today how you were involved in this case?
I was the first officer to respond to reports of a shooting at Strawberry Creek Ranch on October 21st, 2021. Once I arrived there, found the 2 gunshot victims, I secured the scene, and then I began my investigation into who might be responsible for the shooting.
Will you please tell the court how you conducted this investigation?
My investigation focused on 3 broad areas. First, who had had primary responsibility for having firearms on the set and the process that went into hiring them. Second, the conditions under which firearms and ammunition were stored and handled on the set. And third, the specific circumstances on the day of the shooting.
Deputy, I would like to start with your investigation into, as you said, the preparation for having firearms on set and the person that was hired to be responsible. Please tell us where you began that part of your investigation.
I began by speaking to Ms. Brier the day after the shooting.
Why did you speak with Ms. Brier?
Because I figured as executive producer, she was the one who could tell me who had immediate responsibility for firearms on the set.
And during your interview with Ms. Brier, Did you discover this information?
Yes, that was the armor who went by the initials LV.
Did you ask how Ms. Brier knew about LV?
Yes, she said that she had first heard about him from an assistant producer at her previous project, and she said that she then hired him as armor for her next project, Spur, after a brief phone interview, and apparently after making some inquiries to other people in the industry and doing some Google searches.
Did you do any searching of your own about LV?
Yes, I did a basic Google search of LV's initials shortly before speaking to Ms. Brier.
And did you find anything?
Yes, I found an article criticizing firearm safety practices in the film industry that specifically highlighted a certain LV as exemplifying these problems.
Let the record show I'm approaching opposing counsel with what has been pre-admitted into evidence as Exhibit 10, a call to arms, firearms, and film needs industry. Your Honor, permission to approach the witness? Deputy, is this a fair and accurate copy of the article that you found?
Yes.
Is it altered in any way?
No.
All right. Deputy, please tell us what this article is about.
So this is a 2019 article from Eureka News Network calling attention to unsafe handling of firearms in the film industry. It specifically mentions a certain LV. It says that he'd been fired from only his second job as armor for film after a firearm accidentally discharged and injured a crew member. It says that there were similar complaints at his first job as well.
Deputy, how is this article relevant to your investigation?
Well, it certainly called into question LV's qualifications as armor, and I wanted to see if Ms. Brier had been able to find this very easily accessible information during her hiring process, because I thought if she had not been able to find it, it would definitely call into question whether she'd done her due diligence in hiring an armor.
Deputy, did you show this article to Ms. Brier on the day of your interview?
Yes.
And what did she say when you showed it to her?
She'd never seen it before.
Deputy, to clarify for the jury, what, if anything, did you conclude from this part of your investigation?
I concluded that the fact that Ms. Brier had not uncovered this information, which was only a quick Google search away during the process of hiring an armor, again, definitely suggested she had not done her due diligence in hiring an armor.
Deputy, I now want to move to the second part of your investigation, the conditions on the set of Spur. Where did you begin this part of your investigation?
I began by speaking to the crew members immediately after I secured the scene.
And what did these crew members tell you?
They told me that October 21st was not, in fact, the first time that gun safety had been an issue on the set. There had been 2 prior incidents in the preceding weeks where firearms had accidentally discharged on set.
Did the crew members tell you anything else?
Yes, they also told me that apparently some crew members were in the habit of taking firearms and, in fact, live rounds out of storage and using them for target practice on lunch breaks.
Deputy, during your investigation, did you discover any reason for live ammunition to be on set?
Absolutely not. There was no reason for live ammunition to be on the set.
Did you conduct any investigations into the physical evidence on that day regarding the guns and the ammo?
Yes, after speaking to crew members, I went around the set. I found the storage shed that was being used as an armory. I found multiple firearms displayed on racks, as well as ammunition strewn all over the floor of the shed. I also found ammunition in multiple other locations on set.
Deputy, are there guidelines that you teach with respect to the safe storage of firearms?
Yes, so firearms should always be kept stored in a locked container when not in use. More importantly, they should always be kept unloaded when not in use.
And are there guidelines that you teach for the safe storage of ammunition?
Yes, so
this is exactly what I was talking about. He's being asked to testify about the standard practices that should be followed on a film set when he has no experience in these matters.
How are the guidelines that this deputy would teach in his profession and line of work, how are those relevant to this film set?
So if I may make an offer of proof, Deputy Laycook is going to testify that in the guidelines that he prescribes, which again are both for personal and professional settings and which he is paid to instruct on, he teaches that firearm ammunition needs to be stored and clearly marked and organized so that one can differentiate dummy rounds from blanks from real bullets. This is crucial in allowing the jury to make a decision as to whether or not the conditions on Jordan Brier's set were even remotely close to guidelines that, again, an established firearm safety instructor is teaching on a general basis for several years.
Okay, and based on that offer of proof, it sounds like he's able to testify that these guidelines apply in broader situations than just a police department. Is that right?
Yes, that's correct. In professional and in personal settings, Deputy Laycock has given several instruction courses.
Okay, based on that, I will overrule, but feel free to cross-examine or otherwise point this out to the jury.
Yes.
Deputy, I'm going to re-ask my question. Are there guidelines that you teach for the safe storage of ammunition?
Yes, so ammunition should always be stored separately from firearms, and in particular, the utmost care should be taken that live rounds are always clearly distinguishable from dummy rounds or blanks.
During your investigations into the conditions on the set of the film Spur, did you observe these guidelines being followed?
No, they definitely were not followed.
Deputy, and I want to move to the third part of your investigation, as you said, the incident and the day of the shooting. Did you collect any more physical evidence?
Yes, I also went back to the church where the shooting had taken place, and I ended up picking up a firearm and a spent bullet casing from the floor of the church. The firearm was a Hart & Weschler Model 55. I placed the evidence into a secure bag and sent them to the lab for testing.
Did you learn anything else about this particular handgun?
Yes, so after that, Assistant Director Sage Cleveland approached me, and they actually confirmed that that was the gun that Ms. Brier had been holding when it went off and shot the two victims.
Deputy, are you familiar with Hart & Weschler handguns?
Yes, and I also did a brief Google search of them before speaking to Ms. Brier.
What did you find during your Google search?
I found that the previous model of the Hart & Weschler revolver, the Hart & Weschler Model 54, had actually been recalled.
Let the record show I'm approaching opposing counsel with what has been pre-admitted into evidence as Exhibit 11. May I approach the witness?
You may.
Deputy, is this a fair and accurate copy?
Yes.
Has it been altered in any way?
No.
Deputy, will you please tell the court what this notice is?
It's a recall notice for the Hart & Weschler Model 54 revolver. It says that it is being recalled due to a manufacturing defect that makes it prone to accidental discharge.
Deputy, you testified that you did this Google search before you spoke with Ms. Brier.
Yes.
Did you show this article to Ms. Brier?
Yes.
And what did she say when she saw it?
She was not aware that there had been a recall.
Deputy, why did you show this article to Ms. Brier?
I showed it to her because, again, I thought that if she had not been able to find this very easily accessible information, it definitely called into question whether she'd done her due diligence in preparing to have firearms on the set of her film.
During your interview with Ms. Brier, did you discuss her actions on the day of the shooting?
Yes.
And could Ms. Brier tell you who told her the gun was cold?
I don't believe she could recall specifically.
Did she turn the safety on?
She did not.
Did she check the gun personally?
She did not.
Did she see anybody check the gun personally?
She did not.
Deputy, are there guidelines for the safe handling of firearms that you teach?
Yes. So once a firearm is taken out of storage, it is imperative that the chain of who has control over it be carefully monitored at all times. Every new person to come into possession of a firearm should always check whether it is loaded. And finally, in general, every firearm should be treated as if it is loaded at all times.
Deputy, was Ms. Brier able to tell you with certainty that she did not pull the trigger that day?
No.
No further questions, Your Honor.
Thank you, counsel. Cross-examination.
May I proceed, Your Honor?
You may.
Officer Laycock, good afternoon.
Good afternoon.
I'd like to start by discussing with you a little bit further your experience, your background, and your expertise. So you are an expert in firearm safety, correct?
Yes.
And you train people on firearm safety.
Yes.
But you've never trained anybody on firearm safety in regards to proper firearm safety techniques on a film set.
Not specifically when it comes to film sets.
You don't have experience with prop guns.
Prop guns are no different from guns.
Prop guns are no different from guns.
Yes, they can still shoot bullets.
You don't have any experience working on a film set in any capacity, correct?
No,
You don't have any experience working, for example, as a film producer.
no.
So you don't have any experience in regards to what a film producer's roles are on a set,
I wouldn't say so, no.
or what the general delegation of authority is on a film set, let's say between a film producer and an armorer.
I don't have specialized experience in that, no.
You also don't have any experience or expertise on the film industry standard when it comes to how film producers generally hire armorers for their film sets.
No, I wouldn't know specifically how film producers hire armorers.
And just now you testified that you believe that Jordan Brier didn't do her due diligence when she hired LV, correct?
Yes.
But that's not based on any actual expertise that you have.
It is based on the fact that LV was clearly unqualified to be an armorer.
It's based on a guess about what a producer's duties are.
I wouldn't know specifically what a producer's duties are.
And when you spoke to Jordan Brier, she said that she did what the film industry standard is when it comes to hiring armorers on set, correct?
I believe that's what she said, yes.
She said that. So you don't know if Jordan Brier did her due diligence when it came to hiring LV.
I just know that I just know that whatever process she employed to determine if LV was qualified as an armorer, it was not an effective one.
But you don't know if she did her due diligence in the film industry standard, correct?
What I know is about firearm safety protocols. I have no reason to believe that those safety protocols are different just because you're on a film set. So I don't. So whatever protocol she employed to determine that LV was qualified, they were inadequate.
I'm not asking here about firearm safety on set. I'm just asking about how hiring happens for a film set. So you don't know if Jordan Brier did what every other producer would do when hiring an armorer, correct?
I can't say I do, no.
Now let's talk a little bit more about your investigation itself and your process. So when you arrived on the film set, you spoke to several members of the casting crew, correct?
Yes,
Among these was the assistant director, Sage Cleveland.
yes.
And the assistant director told you that they didn't personally check every single round of every single gun just prior to shooting.
I'm sorry, could you repeat the question?
When you heard the assistant director say that she didn't personally check every single round of every single gun just prior to shooting.
I believe that's what she said, yes.
But when you spoke to the assistant director, she also told you that just prior to shooting, she and the armor LV had told Jordan Brier that the gun was cold, correct?
Correct.
Cold as in meaning there was no live ammunition in the gun.
Yes, cold meaning unloaded.
So 2 people had told Jordan Brier that the gun was cold.
Yes, I believe so.
And you also spoke to the armor LV, correct?
Yes.
And LV told you that they did check every single gun and every single round just prior to shooting, correct?
LV told me that it was his job to check whether the guns were loaded. However, he could not recall if he had done that specifically in this instance.
So you determined that it was LV's duty to check every single gun, but that he couldn't recall if he'd done that in this instance.
LV told me that that was what he did, but it seemed he could not recall if he'd done that in this instance.
This was the only conversation you had with LV, correct?
Yes.
You never conducted a follow-up or formal interview with LV, correct?
No, it's not in the report.
You had determined that LV was responsible for most of the firearm safety mishaps on set, correct?
I determined that I had enough evidence to recommend charges against Ms. Brier.
Was that a yes to my question? You had determined that LV was responsible for most of the firearm safety mishaps on set, correct?
I wouldn't say that's what I determined, no.
You just testified that you believe that Jordan Brier is guilty because she hired LV, correct?
I recommended charges against Ms. Brier for that and other reasons.
Largely because she hired LV.
I wouldn't say largely. That was one of my reasons.
But you never conducted a follow-up interview with LV.
No.
Now let's talk a little bit further about the evidence that you collected on set.
Yes.
When you arrived on set, you found a Hart & Weschler Model 55 revolver, correct?
Yes.
And you determined that this was the revolver that had been used in this incident.
Yes.
And about 7 feet away from that revolver, you also found a spent shell casing, correct?
Yes.
And this was a spent shell casing for the Hart & Weschler Model 55.
Yes.
And you found this odd. You found this odd?
No, I wouldn't say I found it odd.
You didn't find it odd.
What would I have found odd?
In your report, don't you state that the Hart & Weschler Model 55 is a revolver-style handgun?
Yes.
And you also state that a revolver-style handgun wouldn't automatically eject a spent shell casing, correct?
It is rare for a firearm to fire without anyone being in contact with the trigger, but it can happen.
I'm not asking about whether or not the gun fired. I'm asking about the spent shell casing.
Sorry, could you repeat the question?
You found a spent shell casing located 7 feet away from the revolver, correct?
Yes.
And this is unusual because Hart & Weschler Model 55 revolvers don't automatically eject shell casings.
I'm sorry, I believe so, yes.
Because somebody would have had to open up the gun, take out the shell casing, and throw it 7 feet away from the revolver, correct?
I would not know that, no.
Isn't that what you state in your report?
If you could refresh my memory.
So you don't recall?
I don't recall specifically talking about the shell casing, no.
Now let's talk a little bit more about this Hart & Weschler Model 55. You say that you are aware that it is possible for guns to fire without anybody touching the trigger, correct?
It's possible, but in my professional opinion, it is rare.
And you don't believe that it happened in this instance?
Personally, I do not.
Now, in your interview with Jordan Brier, you showed Jordan Brier a recall notice, correct?
Yes.
This was a recall notice for the Hart & Weschler Model 54.
Yes.
A recall notice that was issued because these guns had a tendency to fire without anybody pulling the trigger.
Yes.
Misfire.
Yes.
And you asked Jordan Brier about this because you felt that it was a strong possibility that that's what happened in this instance.
I would not say that is why I showed it to her. I wanted to see if she'd been able to find this very easily accessible information about the recall, and that would speak to whether she'd done her due diligence.
So you weren't curious if this is why these misfirings were happening?
I did not show her the recall notice because my theory was that the gun had accidentally misfired.
It was just a curiosity.
It was to see whether she'd been able to find this information about the recall notice.
But the fact that the Hart & Weschler guns were misfiring, that wasn't relevant at all to your investigation.
That was not why I showed her the recall notice, no.
Now, you bagged and tagged the revolver and you sent it off to the lab, correct?
Yes.
You never saw that lab report, did you?
It's not in the report, no.
So you never saw the lab report?
No.
Did you ever follow up with the lab to get the lab report?
I did not consider it necessary to be able to recommend charges against Ms. Brier.
Even though Ms. Brier was saying that she didn't pull the trigger.
She could not recall whether she'd pulled the trigger.
Didn't she say that she would never pull the trigger?
Yes, but she could not recall whether she pulled the trigger.
And so it's an open question whether or not this gun misfired.
Yes.
And you never followed up with the lab to rule that out as a possibility?
I did not consider it necessary to recommend charges, so no.
So just to wrap things up here. By the end of your investigation, you had not determined how a live round had gotten onto the set, correct?
I did not specifically determine who brought live rounds onto the set, but the mere fact that they were there definitely suggests that a lot of things were wrong.
You didn't determine who or how the live round was loaded into this gun?
Not specifically, no.
And you never determined how this gun had actually fired?
I did, to answer your question, no.
No further questions, Your Honor.
Thank you, counsel. Any redirect examination for this witness?
Yes, Your Honor.
Okay,
May I proceed?
you may.
Deputy, on cross-examination, you stated that Sage Cleveland had told you that they told Miss Brier the gun was cold. Is that right?
Yes.
But you interviewed Miss Brier the day after the shooting, didn't you?
Yes.
Did Miss Brier say that Sage Cleveland told her the gun was cold?
No, she cannot recall specifically who told her the gun was cold.
She couldn't remember anyone who told her for a fact the gun was cold.
No. That's correct. She could not remember.
During cross-examination, the defense also asked about your expertise in the film industry. Deputy, how did you find this article about LV again?
For a basic Google search.
Deputy, in your opinion, do you need to be an expert to do a Google search?
No.
No further questions, Your Honor.
Thank you, counsel. Can this witness be excused?
Yes.
Thank you for your testimony. Anything further from the government?
No. No. The government rests.
Does the state rest its case?
Yes.
Okay. We will go ahead and take a 5-minute break, so I'll see both parties back at 2:05 p.m. All right, we are back in session. Are both parties ready to proceed with defense case in chief?
Yes, Your Honor.
Yes, Your Honor.
All right, you can call your first witness.
The defense would like to call Jordan Brier. Good afternoon.
Good afternoon.
Can you please state your first and last name, spelling out your last name for the jury?
My name is Jordan Brier, last name spelled Breyer.
What do you do for work?
I've been an actor and a producer for over 20 years.
Were you working on a film in October 2021?
Yes, I was.
What was the name of that film?
It was called Spur.
And while you were working on Spur in October 2021, what were some of your job responsibilities?
I was the lead actor and producer of the movie.
I'd like to hone in on your responsibilities as lead actor and producer. So what were your responsibilities as a producer for Spur?
Well, I was responsible for hiring cast members, crew members. I was also responsible for managing the budget, overseeing day-to-day operations on set, as well as scouting and booking the set location. Overall, I was responsible for the big picture of making sure the movie was produced.
And what were some of your responsibilities as an actor on set?
I was responsible for performing my lines, sometimes with a prop, sometimes with other actors, as well as being professional and responsible overall.
Overall, how busy were you on set?
I was very busy.
So while you were very busy managing the big picture as the producer and acting on set, who was responsible for managing the little details?
The crew that I hired was responsible for managing the little details.
Did you hire a medic for Spur?
Yes, I did.
Did you hire an armorer for Spur?
Yes, I did.
Who did you hire for the armorer position?
I hired someone who goes by LV.
And what were some of LV's job responsibilities as the armorer?
LV was responsible for maintaining the armory. He was also responsible for general set safety, as well as leading the weekly safety trainings on set.
What happened during those weekly safety trainings?
During the weekly safety trainings, LV would teach everyone about basic gun safety, and I would also be standing up next to him.
Why did you stand up next to him?
I felt that it was really important for everyone to learn gun safety, and I wanted to make sure that my crew members knew that.
And before you were working on Spur, had you attended any gun safety trainings before?
Before Spur, no.
And did you ever need to hold a prop gun while you were working on Spur?
While I was working on Spur, I did need to hold a prop gun.
And what was your experience handling prop guns before you worked on Spur?
Before I worked on Spur, I had no experience handling prop guns.
So other than what LV taught you, what do you know about gun safety on a film set?
Other than what LV taught me, nothing.
And I'd now like to focus on how LV ended up as the armorer. So how did he first end up in the candidate pool?
I first learned about LV through a recommendation from an assistant director that I worked on my last project. When I learned about him, I checked with some other actors, directors, and producers in the industry, and everyone said that LV was reputable and experienced.
And after you heard from different members of the film industry that he was reputable and experienced, what did you do next to evaluate him for the position?
I decided to interview LV.
What happened during the interview?
During the interview, LV told me about their experience as an armor in the past, sometimes even as the lead armor. He also talked about being around guns his whole life, and he even had a firearm safety certificate.
Objection, Your Honor. More prejudicial than probative. May I be heard? You may. If I might make an offer of proof. Sure. I have it on good faith belief that Ms. Brier will admit that she knows nothing about what this gun safety certificate means. This testimony goes to mislead the jury into thinking that LV may be more qualified than he actually is.
Your Honor, may I be heard?
You may.
Ms. Brier is strictly speaking about the contents of this interview, where LV described exactly what his background, his experience was as a candidate trying to convince Ms. Brier to hire him. So she does not speak to anything about what the qualifications of a firearm safety certificate is. If anything, Detective Laycook could go ahead and clarify on that, but he was not given the opportunity to do so today. She's only stating what occurred during this interview.
If I might be heard.
Last word.
I'll take opposing counsel's point and say that that goes even more to show why this has less probative value than its prejudicial value. Because no one can testify to anything about this certificate, the jury has no opportunity to make an informed decision about whether or not LV was qualified.
I'm not going to find that it is substantially more prejudicial than it is probative. To the extent that it could be misleading, I trust you to clear that up on cross-examination, so I'll overrule.
May I re-ask my question?
You may.
What happened during the interview with LV?
LV talked about how he had been around guns his whole life. He had experience in the past as an armor, some even as the lead armor on set, and he even had a firearm safety certificate.
And after conducting this interview, did you look into LV's background at all?
Yes, I performed the industry standard of asking people that I trusted in the industry to inquire about LV's reputation.
And after this interview, what did you decide about LV's candidacy for the position?
I decided to hire LV.
Did you discuss hiring LV with any other crew members?
Yes, I did. I talked about it with Sage Cleveland, my assistant director, via email.
Your Honor, may I approach opposing counsel to show the pre-admitted exhibit of Exhibit 9?
You may.
And also, may I approach the witness to hand her the exhibit?
You may.
Do you recognize this email?
Yes, I do.
What is it?
It is the email that I sent to Sage about my decision to hire LV as the armorer.
And is it a fair and accurate copy of this email?
Yes, it is.
Why did you decide to hire LV?
LV was, they had a great they had a great reputation, and they also had a bunch of experience. I thought I could trust LV to keep the set safe.
Thank you. May I collect Exhibit 9 from the witness?
You may.
Thank you. And I'd now like to discuss safety on set. Were there ever any prior gun accidents on set before the October 21st incident?
Yes, there were.
When did you first find out about those gun accidents?
I first found out about those 2 gun accidents the day after October 21st during my interview with Detective Laycook.
And what did you learn about those 2 prior gun accidents from Detective Laycook?
The detective told me that both of those incidents involved a firearm spontaneously discharging without any warning, just like what happened on October 21st.
And was there live ammunition on set?
Yes, there was.
When did you first find out there was live ammunition present on set?
I first found out during my interview with Detective Laycook on October 22nd.
What did you learn about why there was live ammunition on set?
Apparently, some crew members on set were using the live ammunition for target practice during their lunch breaks.
If you had learned that those crew members were putting live ammunition in the target guns, in the prop guns to use them for target practice, how would you have responded before the October 21st incident?
I would have fired them.
Your Honor, relevance.
Can you explain?
What this witness may or may not have done doesn't go to make it more or less likely that she is guilty of something that already happened. Opposing counsel is attempting to pull out mere hypotheticals that have no bearing on the truth or falsity of what happened on October 21st.
How do you respond to that?
Your Honor, I think that it is credible testimony as to assess as to whether or not Jordan Brier was negligent and created a high risk of death or great bodily injury on her set by not assessing and truly having a perception of the danger of live ammunition being present on set.
May I be heard?
You may.
After the fact commentary about what this defendant wishes she may have done or hypothetically would have done differently 4 years later has no bearing on what she actually did to ensure a safe set and whether or not she's guilty of involuntary manslaughter.
I am concerned about asking the witness hypotheticals, so I'll sustain this.
Understood. Your Honor, I would like to present the witness with Exhibit 1, and may I also show it to both opposing counsel and the witness herself?
You may.
And would you like a courtesy copy of Exhibit 1?
I'm all set. Thank you.
Do you recognize this image?
Yes, I do.
What is it of?
It's a picture of the Spur movie set on Strawberry Creek Ranch.
And is this a fair and accurate copy of this image of the Strawberry Creek Ranch Spur set?
Yes, it is.
Your Honor, I would like to move Exhibit 1 into evidence.
Any objection?
No objections, Your Honor.
Exhibit 1 is entered.
Jordan, how large was the Strawberry Creek Ranch set?
It was very large.
And why was it so large?
It had to be large because it had to fit a full Western town as well as multiple full-size buildings.
And can you please show the jury exactly where that Western town is depicted in Exhibit 1?
In the image, if you see, the Western town is in the top left corner of the image.
And how large was the Spur crew?
It was very large.
So while you were working on this very large set with a big crew, how did you learn about the different happenings on set?
Well, I'm only one person, so I don't have enough eyes and ears to cover the whole set, so I depended on crew members to inform me about their individual areas of expertise.
Did any crew members report either of the 2 prior gun accidents to you?
No, they did not.
Did any crew members report the presence of live ammunition on set to you?
No, they did not.
And I would now like to discuss the events leading up to the October 21st accident. Where were you the morning of October 21st at approximately 9:30 a.m.?
I was in the church on set preparing for rehearsal that day.
And what were you rehearsing?
It was an intense scene where I would draw my gun from its holster and aim it at the camera.
Who was in the room while you were rehearsing?
J.U., Kyrie McLork, and LV was also there.
Did you hold a prop gun while you were rehearsing?
Yes, I did.
How did you receive the prop gun?
LV handed the prop gun to me.
Did LV say anything to you when he handed the prop gun to you?
I think so.
What do you think LV said?
I believe LV told me that I could use the prop gun for rehearsal that day because the gun was cold.
And why do you believe LV said that the gun was cold?
Whenever LV hands me a gun, he always makes sure to tell me that it's safe to use.
And during your time on Spur, when LV would hand you a prop gun and confirm that it was cold, did you trust that LV was a gun expert?
Yes, I did.
Why did you think LV was a gun expert?
I trusted LV because he had a bunch of experience and he had a really good reputation as an armorer that you could trust on set.
So when LV would hand you a prop gun and confirm that it was cold, did you trust his judgment?
Yes, I trusted his judgment.
So what happened after LV handed you the gun?
After LV handed me the gun, Jay directed me on where I should point the gun for the camera angles. So I practiced drawing my gun from its holster 2, maybe 3 times when the gun went off. I guess the bullet hit Jay and Kyrie because Jay collapsed.
Where did you aim the gun when you were practicing, rehearsing with it?
I was aiming it at the camera, just like Jay directed me.
And how were you taught to hold a prop gun?
I'm taught to put my finger on the trigger guard parallel to the barrel, not on the trigger itself.
And for the scene you were rehearsing that day, did it require you to pull the trigger?
No.
Jordan, did you ever pull the trigger that day?
No, I would never pull the trigger.
And when Jay initially fell, did you realize he was shot?
No, I didn't even consider that could be a possibility until an hour later, because as far as I knew, there was no live ammunition on set.
And what happened after Jay and Kyrie were hit with the bullet?
Me, some crew members, and the medic that was on set at the time rushed over to help them. I just broke down crying.
And I'd now like to discuss your interview with Detective Laycock. When did you speak with him?
I spoke to Detective Laycock the day after the October 21st accident on October 22nd.
How were you feeling at the start of the interview?
I was still in shock from what had happened the day before, and I was mourning my friend. Overall, I think I was just feeling really confused about everything.
Objection, Your Honor, relevance.
Can you explain?
Yes, Your Honor. How this witness was feeling while the people are sympathetic to what she's gone through, it has no bearing on what happened the day prior to this interview and whether or not anything is more or less likely in this case.
Response?
Your Honor, Detective Laycock has testified that Ms. Brier was not able to answer all of his questions, and if I may offer proof, I expect that this witness will testify that she was not able to answer all of his questions because of how she was feeling only a day after this traumatic accident. We are trying to essentially establish her credibility.
May I be heard, Your Honor?
Sure.
In that case, I'd like to move my objection from relevance to substantially more prejudicial than probative. If this witness, as opposing counsel just said, intends to recant her entire interview with Deputy Laycock, surely that is far more prejudicial than probative, as it serves to sway the jury to not believe any of the evidence that the people are working with today.
May I be heard, Your Honor?
You may.
We do not expect this witness to recant any of her testimony. We are merely speaking to the fact that there are some points in the interview where she says that she doesn't know an answer. Credibility is always relevant, and it is substantially more probative to establish that this witness is credible.
May I be heard, Your Honor?
Briefly.
We're not going to show whether it's relevant or not. We're going to show if she's saying that she's so incredible that nothing that she said can be believed, that is quite literally the definition of recanting an interview.
I don't think that's where this is headed based on defense counsel's assertion, so I'm going to overrule.
May I re-ask my question, Your Honor?
You may.
How were you feeling at the start of the interview?
I was still in shock from what had happened the day before, and I was mourning my friend Jay. I think overall I was just feeling really confused.
Were you able to answer all of Detective Laycock's questions?
No, I found it challenging to answer some of his questions.
Why did you find it challenging to answer some of his questions?
Well, he kept bringing up things and issues on set that I had no idea about, and I think more than anything, it was hard to keep my thoughts straight because of what had happened the day before.
No further questions. Thank you.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Ms. Brier.
Good afternoon.
I want to talk to you about your responsibilities on the film Spur. You played an instrumental role in the film, right?
Yes, I acted as both the lead actor and producer of the film.
And in your capacity as both the lead actor and the producer of the film, that meant you were involved in making critical decisions.
Yes, I decided things like the set location and the budget.
That's right. You decided the set. You personally selected the Strawberry Creek Ranch for filming, right?
Yes, that's true. I selected the Strawberry Creek Ranch.
You chose this set because it was realistic,
Yes.
because you wanted your film to feel authentic.
Yes.
You also chose the Strawberry Creek Ranch for filming because it was cheap, right?
Yes, finances were an aspect of my decision.
That's right. Your film was on a tight budget.
Yes, that's correct.
It was a priority for you to save money.
Yes, money was important in making sure that the film would be produced.
I want to talk about another one of your responsibilities as producer, and that was hiring crew members, right?
Yes, that's correct.
One of the crew members you hired was an armorer,
Yes.
and that's because your film featured guns.
Yes, that's correct.
Sets with guns on them are more dangerous than other sets.
Yes.
That means you have to take extra precautions.
Yes, and I did so by hiring LV.
That's right. When you hire an armorer, you're hiring someone to oversee weapons on your set, right?
Yes.
That's an important job.
Yes.
People's safety depends on it.
Yes, and I trusted LV would be able to handle all of it.
People's lives depend on it.
Yes.
So it's important to hire someone who's qualified.
Yes.
It's important to hire an expert.
Yes, that's why I hired LV.
So let's talk about who you hired to oversee guns on your set. Like you said, you hired LV.
Yes, that's correct.
Now, you yourself had never previously worked with LV.
Yes, that's correct.
You had never worked with LV?
I had never worked with LV before Spur.
Had you ever met LV before?
No, I had not.
On direct examination, you told the jury that you learned about LV from an assistant director on your previous film. Is that right?
Yes, on my last film, the assistant director that I worked with recommended LV to me.
Ms. Brier, can you tell us this assistant director's name?
No, I can't recall.
You testified on direct examination that you spoke with multiple references. Can you tell us any of their names?
No, it's been 4 years since I've talked to any of them, so I can't remember their names.
So you can't tell us the name of a single person who endorsed LV as a qualified armorer?
Yes, that's correct.
You can't tell us a single name.
Yes, that's correct.
I want to talk about how you hired LV. You conducted one phone interview with LV.
Yes, I hired LV after conducting an interview.
One interview.
Yes, I conducted one interview.
And during that interview, LV didn't share any formal qualifications that he had.
I learned about his experience, both as an armorer and just handling guns throughout his life, and I also learned about his firearm safety certificate.
Let's talk about that firearm safety certificate. You told us that it made you feel reassured, right?
Yes, I felt reassured that he had a firearm safety certificate.
Ms. Brier, can you tell us anything about what this certificate means?
No.
Do you know if it's particularly difficult to obtain?
No.
Do you know if it requires any formal training?
No, I'm unaware.
Any education?
I don't know.
Any qualifications
Any qualifications?
to obtain the certificate?
No, I don't know.
But you felt confident this was enough for you?
Yes, that in addition to his reputation and experience made me feel confident that he would be a good pick for an armorer.
Now, when you spoke with Deputy Laycook told you about an article he found about LV.
Yes.
You had claimed that you conducted a Google search as well.
Yes, I conducted a quick Google search.
But you claimed you didn't find any red flags.
Yes, that's correct.
Permission to approach the witness with what has been entered into evidence as Exhibit 10. Eureka News Network, a call to arms, firearms in film needs fixing. Ms. Brier, this is an article all about LV, right?
Yes, he is mentioned in the article.
It's an article about how there were increasing safety hazards in the film industry.
Yes.
About how armorers on set weren't doing their job.
Yes, that's what the article is about.
In fact, it said that in the industry, all attention had turned to one person.
Yes.
And that person was LV?
Yes, in the article.
It claims LV was fired from their set
Yes.
after a series of complaints,
Yes.
after someone got hurt.
Yes, that's correct.
On direct examination, you also mentioned an email that you sent to your assistant director, Sage Cleveland.
Yes, that's correct.
Permission to approach the witness with what has been pre-admitted into evidence as Exhibit 9, an email from Jordan Brier to Sage Cleveland. Ms. Brier, you told the jury that you shared the hiring news with your fellow crew members, right? Through this email.
Yes, that's correct.
In this email, you don't mention LV's qualifications.
Yes, I didn't mention specifically his qualifications.
You don't ask anyone else on the crew for input into the hiring decision.
As the producer of the film, I made the decision to hire him.
But what you did say was that this is a home run for the budget. Do I have that right?
Yes, that's correct.
So let's talk about what happened on your set. You spoke with Deputy Laycook on October 22nd, the day after the incident.
Yes, that's correct.
And during your interview with Deputy Laycook, he informed you that there had been multiple accidents on your set with guns misfiring.
Yes, that was the first time I learned about these accidents.
Well, when Deputy Laycook asked you about the accidents, you told him you couldn't remember the exact details.
Sorry for clarification. Details of what?
Of the accidents.
Yes, that's correct.
And now you're telling us that you knew nothing about them.
Yes, that's correct.
Ms. Brier, when Deputy Laycook asked you about those incidents, you didn't tell him that you knew nothing about them.
That's correct.
Did you tell him that you knew nothing about them?
I said that I don't know.
Did you tell Deputy Laycook that this was the first you'd heard of it?
Not in those words, no.
Did you tell him that in other words?
No, I said that I didn't know.
Did you tell Deputy Laycook that no one had even brought it to your attention?
No, I didn't tell the detective during the interview.
Objection, Your Honor. We believe that the prosecution is improperly impeaching our witness.
Can you explain?
So if I am following the prosecution's line of questioning correctly, she's trying to establish that in the interview, it does not state that Jordan Brier did not know about the prior incidents on set. First and foremost, she does say, I don't know what you're talking about, not in those exact words, but it does state that. And secondly, we were instructed, as defined by the confines of this proceeding, that anything that is not explicitly mentioned in the record, it is a necessary inference that it did not occur. And so it is a necessary inference that since Jordan Brier did not know about the gun accidents on set, that nobody told her about them.
May I be heard, Your Honor?
You may.
As to the latter portion of what opposing counsel just said, I believe she is confusing the stipulation regarding Deputy Laycook's report. There is a stipulation that says anything not mentioned in the report necessarily did not happen. That only pertains to Deputy Laycook's report. As to the former part of opposing counsel's objection, first, I would say that I have not conducted an impeachment as I have not brought up her testimony. I'm first just trying to elicit an answer from Ms. Brier. But second, I would be more than happy to read the record to the court in order for us to see that Ms. Brier really never did say that she had not heard of these accidents before. Everything I'm asking is perfectly within the confines of her interview.
Your Honor, may I be heard very briefly?
Give me just a moment. So
No
I will
worries.
say my understanding is that the necessary inference rule applies to all witnesses, not just to Detective or Deputy Laycook. I'm not seeing here how how there's an issue with the necessary inference rule here, because my understanding is that counsel is asking about something that was not in the statement. And so that seems to me like it would be in compliance with that rule. So help me understand what the issue is.
I believe that what counsel is trying to establish is that it doesn't actually say whether or not Jordan did not know about what was happening in the interview, when first and foremost, it does state she expresses confusion within the confines of the interview. And apologies, because my second point was going to be that the interview was in the confines of the report.
May I be heard, Your Honor?
Sure.
Deputy Laycock actually asked 2 questions. The first time he asked her about this specific set of incidents, she said she didn't know. And then he asked a follow-up and said, you didn't know what happened or you don't know the details. She further clarified she didn't know the details. If we want to talk about necessary inferences, it seems to me the strongest inference points in favor of this witness knowing that the accidents occurred, but evading the question during her interview with Deputy Laycock.
So it sounds to me like you're amenable to impeaching or refreshing the witness's recollection. I think at this point, there's disagreement between the two of you about how to interpret the statement, and I think it's fair to argue that to the jury. I'm going to overrule the objection, and I do think it would be most helpful if we put the words themselves in front of the witness.
Yes, Your Honor. Permission to approach opposing counsel, or let the record reflect I'm approaching opposing counsel with the interview transcript of Jordan Brier, directing court and counsel's attention to page 34 of the case packet, lines 212. Permission to approach the witness. Granted. Again, directing court and counsel's attention to page 34 of the case packet. That's line 212 of the interview transcript between Deputy Laycock and Ms. Brier. Please read silently as I read aloud. Laycock, your crew members reported that over the past few weeks, there were 2 accidents with prop guns firing on set, both without warning. Recall any of those details? Brier, I don't know. Laycock, you don't know if it happened or you don't know about the details. Brier, that might have happened. I just don't remember exactly when or any of the details if it did. All I know is that nobody was hurt before Jay. It was a safe set. Ms. Brier, those are your words, right?
Yes, that's correct.
I want to move on to talk about what happened on October 21st, 2021, the day J.U. was shot. You were on set preparing for rehearsal?
Yes, that's correct.
Multiple members of the crew were in the church building with you?
Yes, that's correct.
LV walked up to you and handed you the gun.
Yes, LV handed me the gun.
When LV handed you the gun, he didn't say that he had checked the gun to see if it was unloaded, right?
I think he told me.
You think he told you, or you know
so.
he told you?
I think so.
Can you tell the jury for a fact that LV told you the gun was cold?
I cannot.
Did anybody else tell you the gun was cold?
I don't recall.
Did you see anybody check that gun?
I don't recall.
Did you check that gun?
I don't know.
You don't know, or you didn't check the gun?
I don't know if I checked the gun.
You attended multiple safety trainings, Ms. Brier.
Yes, that's correct.
You knew to always check the gun before it was handed or after it was handed to you.
Yes, I knew to check the gun after it was handed to me.
But you didn't check that gun?
No, I didn't see the need because as far as I knew, there was no live ammo on set and it would be an empty gun.
You still didn't turn the safety on?
Yes, that's correct.
During those training sessions that you attended, you were told to treat every gun like it was loaded.
Yes, that's correct.
That even a prop gun with fake ammunition could be extremely dangerous.
Yes, that's correct.
You were told to keep your finger away from the trigger.
Yes, that's correct.
But you can't tell us for sure that you complied with that rule, can you?
Yes, that's correct.
Can you tell us for sure that you complied with the rule to keep your finger away from the trigger?
I don't know if my finger was on the trigger that day, but I would never pull the trigger.
But you can't tell us for a fact that your finger was not on the trigger.
I don't know if my finger was on the trigger.
Regardless, you proceeded to draw the gun and aim it at the camera.
Yes, that's correct.
Ms. Brier, there were multiple members of the crew behind that camera.
Yes, that's correct.
J.U. was behind that camera.
Yes, he was behind the camera as he directed me where to aim the gun for the camera angles.
That's right. J.U. was behind the camera when you aimed the gun.
Yes, that's correct.
Let the record reflect, I'm now reading a portion of the deposition of Kyrie McLorg, directing court and counsel's attention to page 19 of the case packet, page 4 of McLorg's deposition. As a reminder, all objections by both parties have been waived. Question. Okay, what did LV tell you about guns on set? Answer. Then LV talked to us about gun safety. They covered gun basics, how to handle guns, how to handle ammunition, and what we should do whenever a gun is being used on set. LV made a really big deal that even though we were only using prop guns and fake ammunition on set, that they can still be dangerous. So we should treat every gun like it's loaded. It all seemed like common sense to me. Question, how long did that training last? Answer, about 20 minutes. Question, where was Brier when LV was talking about gun safety? Answer, Brier was there for the whole training, standing right up front next to LV. Nothing further, Your Honor.
Thank you, counsel. Any redirect for this witness?
Yes, Your Honor. Jordan, the prosecution just asked you earlier about the budget on Spur. Why were you concerned about maintaining the film budget?
I was concerned because if we ran out of money, the movie wouldn't be made. As producer, it was my responsibility to make sure that I was managing the budget efficiently.
And were any crew members being paid to work on this set?
Yes, crew members were being paid to work on set.
So was it important for the budget to be maintained in order to ensure that all those crew members were paid?
Yes, of course.
And now moving on to your procedure for hiring LV. Why did you not ask about, or excuse me, withdrawn? How long ago did you hire LV?
Well, we were filming in October of 2021, and I hired LV before that, so it would have been about 4 years ago.
And did you conduct a Google search when you were evaluating LV for the position?
Yes, I conducted a quick Google search about LV.
What did you see when you conducted this Google search?
I didn't see anything that was cause for concern.
Your Honor, I would now like to represent the witness with Exhibit 9.
Go ahead.
Jordan, earlier the prosecution had mentioned a line from this email about it being a home run for the budget. Can you read the full last line of that email?
This is a home run for the budget. LV can focus on weapons, we can focus on film, it'll be a safe set.
And why did you trust that it would be a safe set with LV on board?
I trusted that LV would be able to manage the set so that it would be safe because of all of his experience generally around guns and also as an armor in the past. Additionally, his firearm safety certificate made me confident that I could trust him.
And LV ran all of the safety trainings on set. Is that true?
That's correct. LV was responsible for leading all of the safety trainings on set.
And what do you know about LV as an armorer now?
Now I know that I shouldn't have trusted LV.
Objection, Your Honor. Relevance. May I be heard?
Jordan, when you took the gun on the day of the accident, why did you believe that the gun was cold?
Because LV was the expert on guns, and I trusted him to be able to tell me if a gun would be safe to use for rehearsals.
No further questions.
Thank you, counsel.
Yeah, that's fine.
The witness can be excused. Anything further from the defense?
No, Your Honor. Could we request a quick time check as well?
Absolutely.
Prosecution has 20 minutes, 44 seconds. Defense has 21 minutes, 41 seconds.
Does the defense rest its case in chief?
Yes, Your Honor.
All right. Let's take a short break before closing arguments. So let's be back at 2:50 p.m. for closings. Are the parties ready to proceed with closing arguments? Prosecution?
Yes, Your Honor.
Defense?
Yes.
Okay.
May I proceed?
You may.
Your Honor, opposing counsel, members of the jury, it was only a matter of time. On October 21st, 2021, J.U. was living his dream. A Hollywood cinematographer doing what he loved most with people he trusted to be the best of the best. But what he didn't know was that that day would be his last. Because that set wasn't a safe environment. It was a disaster, a mess. Not a dream, a nightmare. But the problem started long before Jordan Brier aimed a loaded gun at J.U. They began when Jordan Brier hired an incompetent armorer, and as the months went on and conditions got worse and worse, it was only a matter of time. As you've heard all the evidence, I'm sure you've noticed the great many things the defense isn't contesting. We all know it was Jordan Brier's job to hire an armorer. No one's denying that both LV and the gun used on set had a reputation for causing people injuries. No one's pretending like safety guidelines were followed on set or like October 21st was the first time a gun misfired under Jordan Brier's watch. The only question is how the person in charge, Jordan Brier, thought any of this was okay. That is why the people have brought a charge of involuntary manslaughter against Jordan Brier. Now, that charge comes with 3 elements. First, the defendant committed a crime or lawful act in an unlawful manner. Second, the defendant committed that crime or lawful act with criminal negligence. And third, that act caused the death of another person. But members of the jury, this really means something much more simple. Did Jordan Brier ignore a major risk, and did ignoring that risk cause the death of JU. Now, at the start of today's trial, my co-counsel, Daniel Casement, told you that we would prove our case beyond a reasonable doubt, and we have met that burden today. Because we haven't just shown you one risk, we've shown you 3 major risks that Jordan Brier blatantly disregarded. She hired an incompetent armorer, her set was chaotic and dangerous, and she aimed a loaded gun at JU's head. So let's take them one by one. Major risk number 1. Jordan Brier hired an incompetent armorer. Jordan Brier wants you to let her walk free because she found someone else to blame. But it doesn't work that way, not when someone loses their life. Don't take my word for it, take the defendant's word for it. She knew it was her job, her responsibility to mitigate the risk that came with having guns on set. That it was her job, her responsibility to hire what she called an expert. So what does she do? She hires the first armorer off the street. Not the first qualified armorer, the first one she learns exists. The defense wants you to believe that Jordan Brier was just doing her job. Doing her job meant doing her due diligence. Now, as you've listened to the evidence today, I'm sure you've noticed that Ms. Brier's words don't always seem to add up. Well, today, members of the jury, you have the opportunity to make sense of them. If you believe Jordan Brier when she claims she did a Google search of LV, then you know she saw that article. The defense wants you to believe that Jordan Brier did enough research on LV and somehow this article about an entire industry turning against one person just didn't pop up. About crew members left injured, guns accidentally misfiring, just didn't pop up. That these so-called references, whose names she can't even tell us, they didn't know anything about it. But we know that if she conducted a Google search and did her due diligence like she wants you to believe, then you know she saw that article. Then she hired LV with the full knowledge that he came with a reputation of hazard, that she ignored the risk. But let's say you want to give Jordan Brier the benefit of the doubt. You want to believe the best in her, that she would not hire LV with that knowledge, that she would not endanger her crew, her friends on her set. Well then, we know she just didn't conduct a Google search at all. If you want to believe the best in Miss Brier, you believe she's not telling the truth. There's no way that these so-called references, if they exist at all, didn't know a thing about this reputation. That any amount of research wouldn't have immediately shown articles about an entire industry turning against one person. Maybe it's just easier to believe that she didn't conduct that search. But remember that the question today that defense counsel told us during opening statements, the question today is what an ordinarily reasonable person would have done. Reasonable people conduct Google searches over far simpler matters. When your leftovers have been sitting in the fridge a couple days too long, you don't know if they're safe to eat, but you don't want to risk a stomachache, what do? When your car is making a weird noise, you don't know what it is, but you don't want to get on the freeway, risk exacerbating a costly repair, or worse, being late to work, what do? Before Jordan Brier aimed a loaded gun at JU's head, what did she do? Nothing. Once she ignored the risk, it was only a matter of time. Major risk number 2. Jordan Brier's set was chaotic and dangerous. Jordan Brier wants you to believe that she just didn't know any better. But it doesn't take an expert to know that having weapons on set comes with consequences. It doesn't take an expert to know that you've got to take precautions. Ms. Brier wants you to believe that once she hired crew members to help her out with gun safety, what she refers as the small details, it was no longer her responsibility. Jordan Brier effectively hired a bull to tend to a china shop and expected nothing to go wrong. You've heard the evidence. You heard about how guns were stored, ammunition, fake bullets, real bullets, all mixed together, safety guidelines broadly and systematically disregarded. Jordan Brier knew about these accidents on set. She knew that there were multiple misfirings before the one that killed J.U. Ms. Brier told you on the stand just minutes ago, she wanted her film to be authentic. She wanted a realistic, wild Western film, and members of the jury, that's what she got. Because that set was the Wild West. Crew members treating safety like a game, playing games with guns, shooting ammunition on their breaks. Once Jordan Brier oversaw a set with these conditions, once she decided to do nothing to improve the safety conditions on set, members of the jury, it was only a matter of time. Major risk number 3. Jordan Brier aimed a loaded gun at J.U.'s head. Jordan Brier is a professional actor. This is what she does best. The best defense she could come up with is maybe LV told her it was cold, but maybe he didn't. That is it. That is the best Jordan Brier could come up with. Trying to call that reasonable doubt, members of the jury, it asks you to doubt your own reason. Because when Jordan Brier was holding that gun in her hand, it wasn't a prop. It was J.U.'s life. Jordan Brier wants you to know all about the safety trainings she attended. She wants you to know how much of a priority it was for her to do everything she could to educate herself on that gun and being safe. But what she didn't do, she didn't check the safety. She didn't check the gun. What she can't tell you, any person who checked it or any person who said they checked it. Once that gun was in Jordan Brier's hand, it was only a matter of time. An incompetent armorer, a dangerous set, and a loaded gun. 3 major risks, all attributable to one person, Jordan Brier. Members of the jury, if at any point you think you or a reasonable person would have done something, anything differently, then you know that Jordan Brier is guilty of involuntary manslaughter. At any step of the way, Jordan Brier had the power to choose safety, to choose caution, and she didn't. So pick your poison. Any one of those 3 risks, well, it's enough. Pair that with the gun in her hand, because once she drew that gun, once she pointed it at J.U.'s head, time ran out. Find Jordan Brier guilty.
Thank you, counsel. Closing argument from the defense.
May I proceed, Your Honor?
You may.
She was told the gun was cold, and Jordan Brier had no reason to suspect otherwise. Members of the jury, in a few moments you will be asked to deliberate upon whether or not my client, Jordan Brier, is guilty beyond a reasonable doubt of involuntary manslaughter. So in closing, I'd like to discuss with you all a little bit more what exactly those terms mean. Involuntary manslaughter and beyond a reasonable doubt. Now, as you've been told, involuntary manslaughter carries with it a standard of what we call criminal negligence. And it's important to understand that criminal negligence is not like the term negligence that you might be familiar with. It doesn't mean that somebody was careless. It doesn't mean that somebody wasn't paying attention. And it doesn't mean that somebody didn't do their job. It means that a reasonable person in the defendant's situation would have known that their actions were likely to result in great bodily injury or death. That means that this case comes down to a simple question. Would a reasonable person holding a prop gun that they believe contained no live ammunition inside of it, a prop gun that they had no reason to believe contained live ammunition inside of it, and a prop gun whose trigger they did not pull, would that person have any reason to believe that their actions were about to hurt somebody, or let alone that they were going to result in the tragic death of J.U.? Of course not. Of course not. So now, let's talk about each of those things a little bit more in detail. Jordan Brier believed that that gun contained no live ammunition inside of it. She had no reason to believe it contained live ammunition inside of it, and she did not pull the trigger. Now, the prosecution has told you that we're trying to blame all of this on the armorer, LV. But that's not the case. They're the ones who have presented all of this evidence demonstrating just how incompetent LV is and was. And it was LV's job to check the firearms just prior to shooting to ensure that they were cold. The officer who investigated this crime spoke to the assistant director, Sage Cleveland, and LV, both of whom, and the assistant director said that they both told Jordan Brier that the gun was cold just prior to shooting. LV told the officer that it was his responsibility to check every single gun, and Jordan trusted the people that she hired to do their jobs. When they handed the gun to Jordan Brier, she was told the gun was cold. She had no reason to suspect otherwise. She had no reason to believe that live ammunition could even be inside this gun. There had been incidents on set that she had no idea had ever happened. Nobody told her about the safety hazards that LV was creating. In large part, and now the prosecution has presented to you this theory that LV should have known, that Jordan Brier should have known all of this. But nobody told her, and she said that if she had known, she would have fired those responsible. So isn't it reasonable to believe that they didn't tell her because they were concerned about losing their jobs or losing the jobs of their coworkers? Nobody told her that these were happening. Now finally, and most importantly, Jordan Brier did not pull the trigger. The officer investigating this crime, who is an expert on firearms, himself told us that Hart & Weschler guns, the model used in this incident, had a history of misfiring. In their close just now, the prosecution mentioned that my client should be found negligent because she was using a gun that had a history of misfirings. Now, of course, it's absurd to think that my client, a layperson at best when it comes to guns, somebody who had no prior knowledge of firearms, would have known that this gun was a safety hazard. That was LV's job. It was LV's job to purchase this equipment and to know whether or not this equipment was safe to use. The average person doesn't know that the Hart & Weschler Model 55 revolver could misfire. And Jordan Brier has been more than clear. She did not and would never pull the trigger. This was a misfire. It was a terrible, terrible accident. So now let's talk a little bit more about that second term, beyond a reasonable doubt. Now, as you know, beyond a reasonable doubt is the highest burden of proof in our legal system. It means that the story the prosecution has told you is the only reasonable explanation for what occurred. The prosecution has said that they have met this burden. And they've met this burden by presenting you with what they say that any one of these three things is true, that therefore you must find Jordan Brier guilty. The first is they say that Jordan Brier is guilty because she hired an armorer that did a bad job. Second, because the set was a chaotic set. And third, because she aimed a loaded gun. So let's talk about each of those things. Jordan Brier hired LV. That's true. And we do not contest the prosecution when they say that LV was a terrible, incompetent armorer. However, the prosecution has presented you no evidence at all that Jordan Brier did anything other than what the typical producer would do when they hired an armorer. She spoke to people that she had worked with before, the assistant director of a previous film, somebody that she worked closely with, who recommended LV to her. She conducted an interview with LV. And the prosecution would like you to think that it's absurd that she only conducted a single interview. That is how most jobs hire. You conduct a single interview. It is incredibly rare to interview for more than that. And finally, they say that obviously Jordan Brier is lying because she didn't find a news item on a Google search, that she's guilty because she didn't click a link. We have no idea how many links or how many things came up on that Google search. We have no idea what that looked like at all. And it is absolutely absurd to think that somebody should be found guilty of a serious crime because they didn't click a link on a Google search. It's absurd. Now finally, the only person who has spoken to you at all with any knowledge or experience when it comes to producing a film, when it comes to what the film industry standard is Jordan Brier. And Jordan Brier has said that she did exactly what every single producer would do when hiring an armorer. That's it. Now, the prosecution has also said that you should find Jordan Brier guilty because this was a chaotic set. They've said that live ammunition and blanks were all being mixed together. That's true. It wasn't Jordan's job to know or to manage any of that. It was LV's job to manage and organize the ammunition being used, to organize the firearms being used. The prosecution wants you to think that Jordan Brier should have been some sort of omnipotent, all-powerful force as a producer, in charge of every little thing that occurred on this set. But that's obviously absurd. She delegated authority, as any good manager does, and she delegated that authority to LV. And LV clearly did a terrible job. And Jordan Brier was never told about the prior safety incidents. They've presented no evidence that she was. In her interview with the cop, she said that she wasn't aware of them. Simple as that. Now, you might think that there are instances when Jordan Brier should have been paying a little bit more attention, should have been a little bit more involved in this or that. And that's fair. But that does not equate to being guilty of involuntary manslaughter. So now let's talk about that final point. They said that Jordan Brier is guilty because she aimed a loaded gun at the camera. Now, they've said that Jordan Brier should have known better in this instance because she had attended safety trainings, and that these safety trainings prepared her to know exactly what to do when handling these prop guns. Who led these safety trainings? It was LV, the person who the prosecution has built their entire case around being an incompetent individual. These safety trainings were 20 minutes long at most. And the idea that LV, who was somehow so incompetent in every other aspect of his job, was then somehow leading safety trainings that should have prepared somebody who had no prior experience with firearms, that Jordan Brier then should have been prepared to make sure that every little thing was checked and safe. It's absurd. We know that LV did a terrible job, and it's absurd to think that his safety trainings were the one part of his work that he somehow excelled at, that he did a good job of preparing Jordan Brier for this moment. Now, they've spoken a lot about responsibility. They've said that ultimately Jordan Brier is guilty because she was responsible for everything that occurred on set. But we know that that's not quite true. We know that LV had a great deal of responsibility on this set, and that LV failed entirely in executing those responsibilities. But I'd like to talk a little bit more about somebody else who had a lot of responsibility when it comes to this case. And that was the officer who investigated this incident, Officer Laycock. Now, you heard Officer Laycock testify that part of the reason why he recommended charges against Jordan Brier was because he felt that she had hired an incompetent armorer. He spoke to that armorer, and the armorer told him, oh yeah, I check every single round just prior to shooting, don't worry, even though that clearly could not have been true. Despite that, Officer Laycock never conducted a follow-up interview with LV, never recommended charges against LV, never asked LV questions such as, why are there live rounds on set? Who brought them there? Who loaded the live round into this gun? These are the things that LV, as the armorer, was the person who most likely capable of answering those questions. Never asked LV a single one of those questions. The officer knew that the firearms used in this incident had a high likelihood of misfiring. Sent this gun off to the lab and never followed up with the lab to ensure that that isn't what happened in this incident. In other words, members of the jury, this was a lazy investigation that has left us with so many unanswered questions. We don't know who brought that live round to set. We don't know who loaded that live round into the gun. And we don't even know why that gun fired. But here's what we do know. We do know that in that moment, on October 21st, 2021, when Jordan Brier is standing on set preparing for the shoot, holding a prop gun, that she has no idea that a live round could possibly be loaded into that gun. No idea at all. The thought of it would never have occurred to her, and it wouldn't have occurred to any reasonable person in her situation. We know that. And for those reasons, members of the jury, we ask that you find our client, Jordan Brier, not guilty. We rest our case.
Thank you, counsel. Rebuttal?
Yes, Your Honor. May I proceed?
You may.
Opposing counsel just told you she was told the gun was cold and she had no reason to suspect otherwise. She was told the gun was cold. Today we heard a lot of things that Miss Brier was told. We know she was told to treat every gun like it was loaded. We know she was told to personally check every single gun that was handed to her before she aimed it at another living person. We know that Miss Brier was instructed that this was an important time to enforce safety procedures when people's lives were on the line. The one thing we don't know she was told is that the gun was cold. The strongest evidence we have that Miss Brier was told the gun was cold is when she said, I think LV might have said something. That is quite literally it, members of the jury. That is the strongest evidence that the defense has that this defendant was told that the gun was cold. No one else claims to have told the defendant the gun was cold. The defendant can't tell us for a fact that she was told this information. She can tell us for a fact, confidently, with no uncertainty, that every other time she practiced a scene, LV would ensure her that the gun was cold. But this time she can't. She had no reason to suspect otherwise. Opposing counsel just came up here and told you that Miss Brier is the most educated when it comes to safety guidelines on set. Opposing counsel worked hard to make sure that Deputy Laycock could not testify about safety guidelines on set. Opposing counsel wants you to believe that the defendant is so credible, so well informed when it comes to safety guidelines on set that she did her job in accordance with the top of the industry. But don't forget, she had no reason to suspect otherwise. It just doesn't add up. An incompetent armorer, a dangerous set, and a loaded gun that no one checked. Those are 3 reasons to suspect otherwise. The defense wants you to believe that Miss Brier was so important, so full of responsibility that she couldn't possibly spend time looking into the safety guidelines on set, but also that she had no reason to suspect otherwise. We don't know that she was told the gun was cold, but we know for a fact that she had ample reasons to suspect otherwise. Find Jordan Brier guilty.
Thank you, counsel. My understanding now is that the jury will go off to deliberate, so to speak, but well done to everyone. Very good job. All right, so before we give you the news that I know everyone is dying to hear, we're going to give you a little bit of feedback. So let's start with our folks in the jury box, if you want to introduce yourselves and give some comments.
Okay, hello? Can you hear me? Okay. So my name is Leah Abraham. I actually judged Bales last year, so I'm really happy to come back. I want to say overall, I had such a good time watching this trial. I was on the edge of my seat, and so, oh, sorry. Hello? Is that better? Okay. So I thank you for making the hours go by really fast, and so I really did enjoy it. And I was a bit familiar with the case it was based off, so it was nice to see kind of almost a reenactment of maybe what was in the headlines. So I'll just give my feedback as to each portion, and I'll try to make it very brief so that everybody else has time as well. So as to the opening statement, Attorney Casement did a really good job, and I thought I'll highlight what I thought was strong was that you use the rule of 3s, which is the right thing to do. It gets people's attention, and it helps you organize your mind as to the facts that you're going to present. And I think that when you talked about the 3 risks that caused this unfortunate incident, I thought you did a good job of highlighting that. It made me look forward to kind of how that evidence was going to come in. I do have a critique of the use of the theme. I'm glad both parties used the theme. I'm a big believer that the theme, while probably won't win or lose you a case, I think it's highly important for the jury to understand what the main reason is, in your case, why the defendant or the accused is guilty. And so it's only a matter of time, to me, isn't exactly why you all said that the accused was guilty. I think your strongest is, that she kind of fell asleep at the job and that she ran a very sloppy set, right? I think that's your argument, and so I think a theme that gets to that is more powerful. It's only a matter of time is kind of amorphous, right? Because is it a matter of time to anybody? Like, would it have happened no matter what? It has to be tied to the accused, right? It has to be, she's the one at fault for this beyond a reasonable doubt. And then as to the defense opening statement, I thought it was a very good theme with that same kind of criteria, which is that it told me very succinctly why you believe that your client was not guilty, is that the gun was cold. That's something that's going to go in your head for a long time. And I thought, the uses of your words were very powerful, referring to the decedent as her friend, using the word accident, all kind of powerfully primed me to know what your argument was. And then it goes to the prosecution witness. I thought that Attorney Casement did a really good job on the direct of their star witness. I thought the witness did a good job as well. I thought Attorney Casement did a really good job
effectively answering the objection. So the other side would object, and you did a very good job kind of taking the stage and not only answering the objection, but also arguing a bit for the jury's benefit. So I thought that was very effective. So then for Attorney Owen, for the cross, very effective cross of the witness. And so I believe when you're the defense especially, your cross should be laser focused as to your main issues that you believe lead to reasonable doubt for your client. And so in this case, right, Attorney Owen was very effective and able to point out the major issues of the investigation and how that leads to a potentially not guilty verdict for their client, which is, it seems to be the main theory is that this gun off went by accident, right? She may have not done the best job, but it seems like there's a doubt as to whether it was actually she pulled the trigger. And so the star witness for the prosecution not really pursuing that issue is a stark problem for the prosecution, and you did a very good job highlighting that. Okay, I'll make it quick, I'm sure. I'm almost done. And then as to the defense witness, I think that you did a very effective job humanizing your client, and at that point, I thought did a good job highlighting that the defendant was not aware of the incidents. At least, I will say now I have an overall issue where I think the defense could have objected more to these questions. The prosecution did a good job in asking a lot of questions, and maybe the ones that kind of towed the line, which is I guess they should do if they're not going to have objections. But there were very good objections that the defense could have made, like asked and answered. So in the cross, Attorney Horvath kind of to great impact repeated some of these questions, even when she got the answer that she wanted. And so that was an easy kind of asked and answered. But because it wasn't objected to, Attorney Horvath had a very effective cross. And so I just want to remind the defense that that's your opportunity that's part of your defense of your client, is to call out these, what you believe is wrong questions, and it also educates to the jury why these questions are problematic. So I think one big issue was, there was this question about this really easy to find article, right? What evidence was in fact, like as far as foundation was presented to suggest it was so easy to find, right? You kind of get to it later in your closing, but that's where you could have capitalized and told and showed to the jury, the prosecution is kind of making these assumptions that it was so easy to find, but you didn't ask any questions. So all we are left is that, I guess, assuming it was going to be super easy to find. So that's one example, I think, where it could have been impactful. So then, got to get to the cross. I thought Attorney Horvath's cross of the defense witness was outstanding. I think to me, it was a tough case factually for the prosecution in some ways, but damn, I felt like that cross put it in play at that point, because a lot of things that I thought were true, it made me wonder about the credibility of the accused at that point. The issue where she said she didn't know about these incidents. I'm sorry, after you crossed her on that issue, it's not clear to me at all that she didn't know about that. And so I thought that was absolutely outstanding and really effective as the defendant. And so I think it put a lot more in play after that prosecution cross. Okay, last. I thought that Attorney Horvath, again, did a very good job. I think at this point, you used kind of these like terms like, what was it? You put a bull in charge of the china shop. I mean, that was brilliant. And that's the kind of stuff I think jurors really like, because it's kind of like, it creates such an imagery for you as the juror, and it gets to the point of what it is, which is that you did it's like, in the end, this armorer might be the bull, but you put them in charge, right? But I thought there was a bit of burden shifting. I don't know if in the rules you're allowed to object at the closing. Okay, great. So at least I know that you did that that was on complying with the rules. But I thought there was a bit of burden shifting. So again, holistically, we're looking at the prosecution. You have to prove every element beyond a reasonable doubt. The defense really only has to find one element at all to get a not guilty. And so I thought that your focus on what the defense said or what the defense did or the defendant testified to me was a little bit burden shifting, and I would rather have heard that you as the prosecution closed every loop, and that was lacking there for me. And then so for Attorney Owen, I really thought you brought it home, like you just brought it home for the jury. And I love that you went to your notes and you quoted exactly what the prosecution said, and you said, I'm going to go through every single one and tell you why it's flawed. And you really did a good job of showing the logical fallacies in some of the prosecution's argument, which is to say, he's not a good armorer, but at the same time, we're supposed to rely that this training, was effective to the accused to know what she shouldn't have done. The whole, when you said didn't click a link, I think that really showed how it really highlighted, well, yeah, it might have been obvious, but there's so many links. Why would it have been obvious for her to click on it? You know what I mean? And so I think just overall, I thought there could have been more I think there should have been more closing about the pillars. Those are what is our bread and butter as defense attorneys. That's what gets your clients found not guilty is the focus, and I think it should have been focused more than just beyond a reasonable doubt, but on the burden on the prosecution, right? The presumption of innocence. So, sorry, thank you for letting me ramble.
Yeah, I agree with all of those statements. I think first of all, I'll just say that you guys did an amazing job. Danny, when you came out, I was on your side. I mean, I love the rule of threes. I mean, you had everything very clearly laid out for me as to what I was supposed to think about and really listen to when the evidence was being presented. And everyone was just so confident and calm and professional. I mean, you guys did an amazing, amazing job. Cait, when you came in, but your opening, the gun was cold, and then you kind of had me a little bit swayed away from Danny after that point, because it was like, okay, well, now there is some doubt here, right? What did she actually know? That's what we cared about. And then, I mean, both of your openings were incredible. It was amazing. I was actually surprised that you guys are just 1Ls, to be honest. With the directs, Danny, again, great job, kept everything focused. You let the witness be the star. You got every, I mean, it being on a litigator, I know it's kind of hard to get out all the evidence that you need, but you got out every single thing that you needed, right? We knew exactly how the set was, where her responsibilities were, you laid everything out. And the witness, I think, played a very good cop too. Very nonchalant with I didn't think this was important. That was incredible. And then Geronimo did the cross, came in very, very forceful, made sure that the testifying officer answered the questions, right? If he hedged a little bit, you kept them on track. You were the star. You were in control of the answers. You were in control of the tempo of the cross. I think you did an amazing job. With Cait's direct, again, perfect. You got out everything that you really needed. You let the witness be the star. I had empathy, I guess, for the witness, because you kind of made it. You humanized your own client, which is, I think, very important when you are a defense attorney, right? And that's all you needed to do. You weren't trying to be you stood back here, you kind of stayed out of the picture, and you just let your own witness be the star, and that was perfect. And Sienna, you did, I think, an amazing job crossing, because you did it in a way that's, like I said, I felt bad for the witness, but you were professional though, right? You were not condescending. You did it in a very professional way that I think some prosecutors can frankly learn from. You're not indignant. You're not incredulous. I mean, you were incredulous, but in a way that I could understand why you were doing it. And like I said, like after you crossed, I was kind of like, oh yeah, maybe she wasn't told these things. I think you could have done a little bit better with the impeachment by asking like specifically, like, did you say this? And then if she says yes or no, then you can impeach her. I mean, that's just more like a technical kind of issue, because then I was a little bit confused after there was an objection whether she had said it or not. And if it's your burden to prove that this wasn't said, then you got to be a little bit more forceful with it and actually bring out exactly what her statement was and then harp on that statement, right? Because even though I didn't know if she said it or not, it's not their burden to say whether she said it or not. It's your burden to say that she didn't actually say that, right? And you need to actually like go for blood at that point. But again, you all were amazing. Sienna, you played the perfect prosecutor, like how a prosecutor should behave. And then with closing, I think this was a tough case for the prosecution, to be honest. But I think that, Sienna, when you did your closing, I actually believe that you believed in your case, which is difficult to do a lot of times. If you are a litigator, sometimes you're going to have your own doubts about the strength of your case, and you're going to know what the weaknesses are, right? But I felt that you felt that there were no weaknesses in your case, even though I felt there were weaknesses in your case. But you almost had me at certain points. I was like, oh, wait, maybe this person is guilty, but that was because like you believed it, and so that kind of caused me to believe it a little bit more, even though I still, so great job. And again, everyone was so, and your cadence was just like so perfect. I mean, you had your cadence with your closing. I mean, you had everything just very good momentum. It was forceful. It was just great. And then Geronimo, with your closing, again, like you came in forceful. I loved how you highlighted the weaknesses of the prosecution's case. You humanized your client as well. You talked about every single weakness in their case, right? And what we were thinking too is, where's this armor, right? And you pointed that out perfectly. You didn't. I mean, you questioned the prosecution's case in a very professional manner as well, right? You didn't go ad hominem. You just said, this is their burden. This is what they're supposed to do. These are all the questions that are still left open. And you did that in a very, very professional way. And I really appreciated that. And I just think overall what I really liked is how professional everyone was with each other. I mean, you could tell that you guys are, competing here, but you can tell that there was like professionalism and respect among everybody, and I really, really appreciated it. And I would not like to go against Sienna in a trial.
I agree with all the points that Leah and Gilbert have made. You two, both teams were really fantastic. And everything that they said, you did great. I agree with. Lots of confidence, really good command of the facts, the structure and organization on both sides. You both had a theme. You both had the 3 facts, which is a very familiar format in trial advocacy for a reason, because it helps the jury organize and remember the information that you're giving them. And really good job thinking on your feet and just projecting confidence, which I know is a skill. It's, you acted confident at every point in the trial. I know you didn't feel confident at every point in the trial because I've been there, and that it's a skill to learn how to to appear confident when you don't feel it, and you've all really mastered that skill. And another thing that everyone did well was demonstrate your knowledge of the proper procedure. You all know what an opening statement is, that you can't argue in an opening statement, that that's for closing, that you ask open-ended questions on direct and leading questions on cross. You all did a really great job of demonstrating those fundamentals, which is really good to see. Places I think you can work on, the big thing I will point out is I think everyone can slow down. And I mean this in a couple of ways. I mean, literally in terms of how fast you are saying your words as you're speaking. And also I mean slow down the way that you present information and facts to the jury. When I'm working on an opening statement, I like to do one fact per sentence. Like literally, today you will hear from X witness. X witness's name is Y. Y does this job. And let the facts build on each other, because if you come out of the gate with, today you'll hear from so-and-so who does this, and that person will tell you all in one sentence, the jury just cannot fit all of that in their brains or process all that new information at the same time. So, and because you all have such good command of the facts, I think sometimes it's easy for you to forget. We may not have ever heard, and especially members of a real jury may not have ever heard the word armorer before. They may really need to be spoon-fed. Members of the jury, you've probably never worked on a film set before. So let me tell you, when a film requires weapons, they have to fill this additional role. It's something called an armor. Really sort of spoon-feeding that information is important. The more you can use exhibits and visuals, the better. And I know you probably knew that we each of the jurors had a copy of the case so we could follow along with the exhibits, but usually the jurors don't. Usually you have to remember to publish things to them, and that's just a great way. If you're using a document, it's just a great way to hand it to the jury or wave it around in closing, just to say hey, it's not just me talking, we have something else that supports our case. So the more that you can, especially for visual learners, the more you can rely on that evidence, which all of you did a really good job of getting in throughout the course of the trial, is really powerful. And the last thing I'll say is, I think I caught on both sides one or two instances of overstating the facts. You wanted the facts to be something that they weren't quite, and so you just kind of rolled with your version of them. And the problem with that is it affects your credibility, which is the number one most important thing, in the jury's eyes, is whether they can trust you in the arguments you're making. So yeah, it is your job to deal with the facts as they come in, as the witness says them, even if it's not how you were hoping they would say them, and say to the jury, it may be true that it came out this way, but X, Y, and Z, here's why I still win my case. So, but yeah, overall, an incredibly high level of performance. I want you all to know I'm one of the co-directors of Berkeley's external trial competitions team, and I really hope to see you all at tryouts for that team this semester, because this was phenomenal work from all of you, and you should all be very proud. And I will. Oh.
Does this work? All right, mic is hot. I know we gave a round of applause to the amazing advocacy we saw here. Can we also give a round of applause to our judges who did just a really fantastic job helping us out with today's trial? There is going to be a reception right after this that you're all welcome to join us at in the Warren Room. By the way, my name is Natalie Winters. I have the pleasure of being the executive director of Berkeley Law's competitions program, and I have the honor and also kind of tough job of announcing who was ultimately the winner of today's mock trial. It's important for you all to know that the judges were not deciding the merits of this case in the way that a real jury would. They were given a list of objective criteria that was already applied in preliminary rounds in the Bales competition, and ultimately the decisions that were made about who won today was really about the trial advocacy skills that were demonstrated, not whether or not this person would have been guilty. Okay. With all of that in mind, I do want to make sure, without further ado, and announce to you the winners of this year's 2025 Bales trial competition. The winning team is the defense, Geronimo and Cait. Please give a congratulations to our prosecution team as well, who did a fantastic job. It was close. Thank you all for coming. Have a great weekend.